Welcome.
Thank you, Chair.
We also have Honorable Anne Amadi, who is the Chief Registrar of the Judiciary and Secretary to JSC.
Good morning, Judge.
Good morning, Your Honor.
Also, we have Frida Mukaya, who is the Registrar of JSC at the corner there.
Thank you, Your Honor.
So once again, welcome, Judge. A few housekeeping issues. Please be precise in your answers as much as you can so that we can manage time. And I'm also asking my fellow commissioners to also be precise in their questions and also keep within the timelines that we have decided. Your Honor, feel free to ask for clarification if you're not sure or if you didn't hear the question properly, so that you are able to answer the questions properly. After 2 hours, we are going to take a break, and Anne Amadi will come for you to take you where you're going to have your break. Or maybe you can even go to your office because it's around here.
Yes.
Okay, so you now start with the interviews. And I'll start, Your Honor, by asking a question. We have read your very impressive CV. You have done a lot of work for Judiciary the last 30 years. And in 10 minutes, because the rest of the details will come through the questions, but in 10 minutes, please summarize why this commission should nominate you for the position of CJ.
Thank you, Chair. Thank you, Commissioners. I joined the Judiciary 34 years ago in 1987 as a district magistrate, professional, that's what they were called those days. In those 34 years, I have risen through the ranks to become a judge of the Court of Appeal where I am today. 3 years ago, my colleagues in the Court of Appeal identified me to be their captain and unanimously elected me as their president. As I steer the Court of Appeal, I'm pleased to tell the commissioners here, that the court, despite the numbers which we are all aware of, has done a great job under my leadership. The court has been able to put in place case management systems that have seen it reduce the backlog in that court. When I took over, there were 7,000 or so appeals pending. 2 years later, they were down to 4,000. We had and finalized 3,000 through active case management. Unfortunately, the numbers kept dwindling. Unfortunately, COVID-19 came, and these numbers have started rising, heading back to 7,000, 8,000. The Court of Appeal, under my leadership, is regarded as one of those courts that are most collegiate, where judges work together. There's chemistry in the way we work. The Court of Appeal is also known for delivery of robust decisions. But all this has been because of my leadership, because when I took over, we identified as a court the gaps, one of which was the backlog at the time, the delays in judgments. We had judgments that had been pending from our court up to 3 years undelivered. We took a deliberate decision together that all those judgments we sat in June of 2018, April 2018, and we agreed that by June 2018 we must have all those judgments delivered. So when we assembled in June again to review, we noted that we still had a few left. The judges had worked really, really hard to reduce the backlog of delayed judgments. So we extended time to August, and by August, all those judgments were delivered. As I speak to you today, Commissioners, there is no delayed judgment in that court. Perhaps 1 or 2, 5 months or 6 months, again through leadership of myself. How did I get to the Court of Appeal? And I want just to add that when I was elected by my colleagues, I was not the senior most. In a list of 20, I was number 13 in terms of seniority. In terms of age, perhaps the same number. And so they saw something in me that they identified with, that they thought would make a difference in the court, hence the unanimous decision to pick me as their leader. And I want to trace my journey to the Court of Appeal from the time I joined in 1987 as a district magistrate. As a district magistrate, again, I was identified, having worked only for 1 year, working in this very building as a district magistrate and dealing mainly with criminal cases. The chief magistrate at the time, Mr. Justice Mango, identified me to head the traffic court. And he told me in particular that that court had had problems of integrity. Each time a magistrate was posted there, it became a toll station. And he said, I want you to streamline it. He made me in charge of that court. He asked me to ensure that more traffic courts are established in Nairobi and its environs, and I did that. 1 year later, while still a district magistrate, I was promoted my second year in the Judiciary to the position of resident magistrate. Hardly had I done a case, then I was called by a team of JSC members, just 2 of them, Mr. Justice Nyarangi, who was then in the Court of Appeal representing that court to the Commission, and Lady Justice Joyce Alwatch, who was representing the High Court. When I got a call that I was required to go before them, my reaction was panic because I didn't know why I was required before the Commission members. With them was Mr. Justice Mwera, who was then the Registrar of the High Court. That's how they were called, a misnomer, because the Registrar of the High Court was really the Chief Registrar of the Judiciary at the time. With them again was Mr. Jacob Olekipuri, who was then the Deputy to Justice Mwera. And I was told that the two had their hands full as administrators. The more we were expanding, but the administration only had 2 people to help the Chief Justice, so they wanted a third hand. The truth of the matter was that Mr. Justice Mwera was being elevated to the High Court, and Mr. Jacob Olekipuri was taking over as the Registrar. So they picked me as a deputy to Mr. Jacob Olekipuri as the Deputy Registrar. Working in administration, which I did for 17 years, exposed me to many things. While serving as Chief Court Administrator, which was the highest at the time, actually had just been created, I was the first person to occupy that office, and 2 others did after me, or 3 others. I was exposed to many things in the court system. I made so many reform initiatives that we enjoy up to this day as a judiciary, and I just want to give a few examples. The medical scheme we are having today, it was my brainchild, and this is how it happened. I'll be very brief. As judges, magistrates, and other judicial officers and staff, we were being paid a medical allowance or up to the standard of your cadre, all put together under the printed budget came to something like 20 million. And then we had also a line called ex gratia medical, which came to about 30 million. I worked out these figures. We commissioned a healthcare provider, and I approached PS Treasury with these figures of 50 million, having consulted very widely among our colleagues, and I traded off. I said, take away the medical allowance that is in our salary, and take away the ex gratia vote, and we get a medical cover. And we started off with one officer alone, first year. The second year, an officer and a spouse. It has grown today to an officer, a spouse, and I think 4 children. Per diem that we today receive when we travel on official duties, again my brainchild, because of the demeaning manner people were surrendering impressed. You are given 10,000 to go to Kisumu on official duties. You only spend 3, but when you come, you have to account for 7. And you'd see all manner of receipts. It was quite demeaning even for judges. And if you didn't surrender, then of course next trip, you would not go. Again, I negotiated this with the PS Treasury at the time, and they changed it to per diem that we enjoy today, so you don't have to account every a day is costed, and if you go for 10 days, you're paid equivalent. Apart from those two, in administration, I also took part in many reform initiatives. I was appointed a joint secretary to the Kotut Committee by the President of the Republic, the late Daniel Arap Moi. And Kotut Committee was formed to delink or to address issues of terms and conditions of service of the judiciary. The Kotut Committee made a report that completely delinked the judiciary from the mainstream civil service. The judiciary, for years, from independence, was an appendage of the Attorney General's chambers. All our staff, all secretaries, clerks, executive officers, all were seconded from the Public Service Commission to the judiciary. With the Kotut Committee and the report, this came to an end, and we adopted, so to speak, those who are seconded to us. Hence, that's the time we started using PLS 1, PLS up to I think 12 or 13, which have now been converted under your organization review. And that's how we delinked completely from the mainstream public service. The other thing we wanted to do after the Kotut, I was part of the implementation committee that was to implement this, was to completely identify our needs. And one of those needs was to try and have our own pension scheme, away from the one that is enjoyed by the civil servants. I will, if you ask me later, I'll be able to say more about this. I then was appointed as a secretary again to work in the famous Quach committee, again dealing with issues of judicial integrity. Again, after that, I was part of the implementation team that was implementing the recommendations. Finally, a meeting was called by the then Minister for Constitutional Affairs, the late Mutula Kilonzo, with the Chief Justice at the time, Honorable Mr. Justice Gisheru, and the Emeritus Attorney General Amos Ouko. Of the Court of Appeal judges at the time, a few High Court judges and law society and many players in the justice sector, the issue was reform. At the time, reform was in the air. This was after the Kriegler Commission and all that. In that meeting, again, I was perhaps the youngest and perhaps the most junior. I was asked to chair a task force that was appointed to look at the reforms in the judiciary. That task force was multi-sectoral. The current Speaker of National Assembly was a member. The Honorable Mr. Justice Lenaola of the Supreme Court was a member. Senator Okongo Mogeni was my vice. And I can go on, and it was multi-sectoral. Apart from myself and Mr. Justice Lenaola, most of the members were from outside. We did our work, and that work is reflected in Chapter 10 of today's Constitution. This commission, as constituted today, was recommended in that task force. And so many other things that are in that chapter came from the task force. So, Chair, I believe that with my qualification, that with my training in court administration, with all the things I've done to bring change to the judiciary, that I'm capable of moving this institution from where it is to another level. I thank you.
Thank you very much, Your Honor, for that explanation. My second question is regarding your time in judiciary as an insider, Your Honor, and you interacted closely with Emeritus Judge Mutunga and also Emeritus Judge Maraga, and both who came up with great initiatives, great blueprints. So my question is, what reasons do you think interfered or affected their ability to implement those blueprints to, fully? I'm asking that because there are still gaps. I mean, there's still ICT issues, there's still case management issues. So what affected, these great ideas not to be implemented fully?
Thank you. Correct observation. The two Chief Justices did great jobs. Chief Justice Mutunga laid a very firm foundation on issues of access to justice, built many courts, opened up the engagement, employment, and appointment of judges and staff. Did a great job in this institution. And Chief Justice Maraga picked from there and has also done great things. He has brought sense of independence to all of us who work in the judiciary. But as you said, each one of them came with a blueprint, building on each other. And these blueprints, when you look at them, Mr. Justice Mutunga's blueprint, JTF, has 4 pillars, which are more or less replicated in the 6 pillars in Mr. Justice Maraga's SJT. Reform process is indeed a process. It is not a one-off thing. Even those jurisdictions that have developed, they have gone stage by stage. But I think really a critical look at the implementation of the reports, I do not see a focused approach. I think there's a bit of distraction because we are coming out with too many other things. If you look at the policy documents that we roll out, which are all meant to further these reforms, I think they take us off. And I think we need to really, really focus on those recommendations that are aimed at enhancing access to justice. So I would say that we need to just focus and, of course, prioritize those that are low-hanging fruits and those that are medium-term as well as long-term. Once we identify them, we should be able to see the movement clearly. But as it is now, there are many, many things happening around us, very useful things. Perhaps the coordination. Thank you, Chair.
Your Honor, you have talked of focus and coordination. Money was not an issue that we should maybe also address?
Thank you. Yes, money has always been a big issue ever since. Even when I was the accounting officer, money has been a big issue in the judiciary. Just to digress, up to 2003, just before I was appointed a judge of the High Court, the budget of the judiciary was 800 million. We had not reached $1 billion. Out of the 800 million, we were expected to raise in appropriations in aid 300 million. The Exchequer was therefore giving us only 500. This has really grown, really grown. It's to some of us who worked in the judiciary in the early days, this is really a dream come true, that now you can talk of 17 billion to the judiciary. But the judiciary has also grown in numbers and in activities. And so money is very critical in reform. Thank you.
Thank you, Your Honor. How would you describe your leadership style? Are you democratic, maybe too democratic? Are you authoritative? How would you describe yourself as a leader, Your Honor?
I am very democratic. And my colleagues in the court will tell you, no decision is taken from my office alone. Just to give you one example, everything we do in that court is done as a team. I'm just a leader. We looked at the number of applications pending in our court, 1,700 applications. Some were filed 4 years ago. Applications for stay, for injunction, simple applications. After I identified the problem as the team leader, I assembled the judges and staff, and I told them this is the problem. I knew what I wanted. I wanted us to clear this backlog of applications. And proposals came from the floor. We want to hear these applications. Can we list? Normally we list only 4 applications. I wanted to push them a little to list 6. It came from the floor that we list 15. Again, it was reviewed to 9. And we went out, and in 16 days, we had done 600 applications. And results are out there, rulings delivered. One thing, again, we agreed as a court is to borrow what the Supreme Court has adopted. The applications, you don't have to do 13, 15 pages. These are applications that are run of the mill. And so we agreed we would reduce the number of pages, and we were able to achieve. So through consultation, through teamwork, the court has been able to work together and gel very well.
Thank you, Judge. There are no times when you put that authoritarian hat at all.
Oh, yes. Sometimes you cannot, even as a democratic leader, there are times, a time comes when you have to insist that what you think is best for the team is what has to be done. And sometimes, yes, I do.
Thank you. My last question, Your Honor, is again checking your CV. I noticed that you are a member of the Judiciary Honors Committee since 2018. And one of the candidates that we have interviewed this week, Your Honor, said that there's no criteria, and if it is there, it's not well known, which determines or which, so that one is able to predict who qualifies for that award. So my question is, again, look at your CV, Your Honor. I realize that you got the Order of the Burning Spear, EBS, in 2019, and also got the higher one, which is the Order of the Chief of the Burning Spear, in 2020. That is two very heavy honors in 2 years. So in 2 consecutive years, because there's nothing wrong with the honors. I think you deserve them. But then when they come in 2 consecutive years, my question is, much as you may be deserving your honor, was this due to your membership of that committee, or how did that happen? And number 2, could you have given a chance to one of your other colleagues in the judiciary who deserve to get this honor, so that you don't get 2 of them consecutive? And I'm saying this, Your Honor, knowing that you don't give the awards yourself. Your committee was recommending, but I'm just thinking that it looks a bit odd that you're honored 2 consecutive years. Maybe you can explain to us.
Thank you. Yes, Chair. I am a member of the Honors Committee that is chaired by the Honorable the Chief Justice. We have only had 2 or 3 meetings. There's an Act of Parliament that deals with honors, and there's a criteria that is used to award honors. And we are just advisory as a Judiciary Honors Committee. We forward names which are received from different courts, different divisions, from different cadres to the National Honors Committee that I think is chaired by the Deputy President. It is there that they now choose who to give. And so it's not, we make a recommendation. Why I ended up with the 2? One, because it was realized that the honor that had been given earlier was lower than the level a judge ought to be given. So we made a case for the judges of the Court of Appeal, because they're the only ones who are getting that lower grade. So when we sent the names afresh to be given those honors, only myself and I think Mr. Justice Kiagi got the higher one. I don't know how they picked the 2 of us and left the rest. So it's not that I used perhaps my membership in the committee to do this. This is, it's quite, perhaps it's not very transparent also. We simply write to the courts, to the directorates, to nominate those they want to be awarded these honors. And from the list, we don't make any amendments, we send it as it is. Amendments are done in the National Committee. And we give everybody a chance. In my court, a secretary got, because she's outstanding in her work. Thank you.
So if you became CJ, is this an area that you would want to work on, so that hardworking judges and judicial officers also get these honors? Is this something you would want to improve? Maybe come up with a criteria, maybe people can apply if they feel that given certain qualifications or achievements they deserve. Is it something that you might want to change?
Yes, because I don't know how each unit identifies those to be brought to the committee. We need to make it also very transparent from those units, that everybody in the court, if it's magistracy, let all the magistrates know that this is happening this week, and we are nominating those we think have distinguished themselves. And so it is something that should be given as a reward for some achievement and not for any other consideration.
Okay, I think I'll add there, but just a disclaimer, Your Honor, that some of us have those 2 awards. My only problem was the consecutive years, so, but you have explained, and thank you very much.
Thank you.
I now request Acting CJ to continue the questions.
Thank you. My Lord, just before we leave that point of the honors, you have described to us what you've done in your long service in the judiciary. Is it not true that the Chief Justice has in fact never chaired any of the honors committees, and that in effect you are actually the chair, my Lord?
I can't say that the Chief Justice has never chaired. The retired Chief Justice asked me towards the end of last year to chair on his behalf, and I've chaired 2 meetings. So I do not know. That was really my first interaction with the committee, so I can't tell whether there were earlier meetings.
No, I'm talking. This is important because not only did Judge raise it, you know there are mamas in the institution. You live here, don't you? So you know what our people have been saying about those honors. So I think it is a topic that we ought to make closure about, and this may be the opportunity.
I agree.
Emeritus Chief Justice Maraga, for the last 2, actually for the 4 years that he was here, he did not chair an honors committee meeting. He always delegated that to judges, and you are one of the judges to whom chairship was delegated in the last 2 years of his term. That's my concern, because I want to ask one other question on the issue. Is that correct?
Yes, as I said, I really do not know the circumstances under which the retired Chief Justice asked me to chair. I thought it was a temporary thing. I didn't know, because under the Act, he is the chair.
He is the chair under the Act. Let us confine ourselves to the period you were chair. He never chaired during your membership, did he?
No.
No, he did not. And therefore, that would be a serious place to start reform. You agree?
I do.
As Chief Justice, my Lord, you would be the Chief Judge and the Chief Administrator of the institution of the Judiciary. Is that a correct statement?
True.
Let for now our concern remain with the Chief Administrator. You appear to have got to administration quite early in your days in the judiciary, correct?
Yeah, true.
As early as?
1989.
Since then, you've been, my Lord, in internal leadership of the institution of the judiciary. Now, being specific to yourself, forget the committees out there. Please tell us what your specific contribution has been to the benefit of the institution internally. I heard what my Lord said about the pension. I heard what my Lord said about the medical. But this institution is concerned with more than those two. My Lord would agree?
Yes.
So, as regards, and I heard what my Lord said about being president of the court for the last 3 years, and what the court as a team is doing under my Lord's leadership, correct?
Sure.
So now, my Lord, would you give us specific achievements under the 2 heads, administrative and judicial, for that period, my Lord?
I said I have served in administration for 17 years, and in administration your duties are confined to the management of the court, staff, provision of tools of trade, facilitating the judges and staff. And as I said earlier, for administration, there is a lot that I did. I just mentioned two. I can also add pensions, as you've raised it. We started following the issue of pensions in the 90s, and it's one thing that has remained as a scar in my heart, that we've not been able to bring it to closure. But I'm pleased to say again that there's a lot that was achieved also. The magistrates and staff, magistrates and the other staff now have a separate scheme from the public service scheme. Is a contributory superannuation scheme, and that was as a result of my work in the committee that was looking at it. It is that committee that made a proposal to the Retirement Benefits Deputy President and Designated State Officers Act that introduced an amendment to include in that act, because it was taking so long to get the judges' pension running, to include the Chief Justice and the Deputy Chief Justice in that act. My contribution as a magistrate was really brief. I only rose up to RM, and when I became a High Court judge, I believe my decisions when I was fasted to Malindi, I made decisions regarding the purpose and objective of using assessors in criminal trials, and I made a very strong case that it was not useful if the courts were not going to use their opinions to arrive at a determination of a criminal trial. And I believe as a result of that, I saw more or less a few years later, the use of assessors in criminal trials were deleted from our statutes. A very useful thing, something, if you asked me, we can go back to, but make their opinion useful, rather than just have them there give an opinion that you can rubbish. I made decisions regarding when I was in the High Court, regarding the use of confession before magistrates. And I thought that to confess a crime before a magistrate who is presiding in a criminal case was to take a magistrate to be part of the investigating team. I thought personally that it was not in order to call a magistrate to go before another magistrate under a trial within a trial to say that I did not torture, I did not promise. I made a decision to that effect. In Nakuru, I made another decision that has gone all the way, lady, to your court, Supreme Court. This is a wildlife-human conflict, where I made a decision that it is the role of KWS to ensure that wild animals remain where they belong, and that if they escape and harm human or interfere with human activity like agriculture, then KWS is responsible, a decision that was upheld. In the Court of Appeal, I've also made my contribution in the jurisprudence of that court, and I have shared with the commissioners some of my decisions, among very many others.
Thank you, my lord. As Chief Administrator, my lord will be required to ensure that there is full implementation to the greatest extent of the policies that guide the way the judiciary does things, and to improve from where we are at, right?
Yes.
Now listen to this. The principal judge of the High Court is a lady. The principal judge of the Employment and Labor Relations Court is a lady. The chief registrar of the Judiciary is a lady. The acting president of the Court of Appeal is a lady. The acting chief justice of the Republic is a lady. I hope, by the way, my lord, that the two acting ladies may be acting, but I hope they are not playing with their duties. That said, my lord, the gender audit report, which I am sure my lord has interacted with,
Yes.
Met with a lot of dissatisfaction from the female constituency of the judiciary, that there are no ladies. It wasn't that there are not enough, there are no ladies in leadership positions in this institution. Would my lord very briefly discuss that?
Do what? Sorry.
Would my lord very briefly wish to say something about the audit, the gender audit report?
Thank you very much, my lady, CJ. We are blessed to have the only person you forgot to mention, my lady, is the CRJ.
I did.
Oh, you did. Thank you. And the registrar of the commission. And so the list goes on and on.
We're talking about the judiciary, my lord.
Thank you. So that audit report, to me, has acquitted the judiciary in terms of its gender sensitivity, because it is nearly 50-50. The ladies are, I think, 49 point something, and the male 50 something percent. And so I think, compared to the other branches of government that I believe are struggling, look at the executive, look at parliament, I think we are far ahead of the rest. And I want just to commend the commission for bearing in mind this very critical aspect of our lives today, to balance. And I have no doubt at all that in those positions, the ladies are delivering, just like men would. They are ladies. For instance, your ladyship, you have been able to hold this fort. You call us as JLAC for meetings to make decisions. We have seen, we have had any gap at all. You can't know that the actual Chief Justice retired and somebody is acting. The same thing in the Court of Appeal, where Lady Justice Wanjiru Karanji is acting in my place. I don't receive a telephone call from her to ask me, how do I do this? Because she has a free hand, and I think she's done a great job so far.
My lord, allow me to say this. The concerns from our female constituency, my lord, is this, that they are not enough, and I don't think JSC has a role in this, unless I'm mistaken. There are not enough females in top leadership positions in our institutions. So, as chief administrator, how would my lord, the CJ, promote that? Because I think it's also fun. Okay, fine. Go on, my lord.
I do not have statistics of the other levels. I know the High Court. I think we are doing very well, just like in the Court of Appeal, the judges, and even the staff. But I do not have statistics of gender in the magistracy and in the other administrative arms, the directorates and the staff. But there ought to be a way of seeing that everybody has equal opportunity. And if we realize that in some areas there's imbalance, is to balance the imbalance.
Thank you, my lord. Or in fact, is it not true that we are all over the place in the institution of the judiciary? It's just that we don't communicate sufficiently. Isn't that one of our greatest challenges? And how would my Lord CJ improve that? Because the dissatisfaction will continue for as long as things are being done opaquely. Does my Lord agree?
I agree, my lady, fully. We are too hierarchical to begin with. We sit in our corners and forget there are other people around us. The Supreme Court does its thing, the Court of Appeal its thing. We are just all of us, my lady has said. There's need really as a family of the judiciary to have a way of communicating. We have had good and bad times. We have had colleagues who have departed. Again, we do not see any coordination. People just do things in their personal way. And I think really there's need for us to unite.
And so, what is my Lord going to do to correct this situation as Chief Justice Ouko? That's what we're looking for.
Thank you. We have in every station a leadership and management teams. Through these teams, we can be able to communicate. We have the Judiciary Leadership Advisory Council, which needs to coordinate all these teams to work together. That council, I can say, has done a great job also. Even during COVID, the council has been giving directions together with, of course, NCAJ. But that council perhaps needs to be expanded, in my view. There are people who can offer some leadership in the council. And so what I'll do is to ensure that there's synergy between the teams on the ground and the council at the headquarters.
Thank you, my Lord. Let's go to the second issue under that topic, and it is this, my Lord. The 2010 report on the Task Force on Judicial Reforms proposed that there be a separation between the judicial function and the administrative function. Would my Lord please tell the Commission where we are at currently with that? What role my Lord has played up to now, and what role my Lord will continue to play as Chief Justice, giving specific recommendations on how to attain optimum results from the separation.
Thank you, my lady. For many years, the magistrates and judges who are heads of stations were doubling up also as the administrators. And so before a magistrate or a judge goes to court, he or she has to deal with issues of leaking roof, issues of discipline, a broken car. And so much time was being taken off court work for administrative duties. That report, that recommendation your ladyship has identified was to address that, to take away the magistrates and judges from the corridors, from the yard, to go to court. I'm aware that we now have administrators in the stations who are helping with administrative work so that the judges and magistrates can concentrate on their core business. As to what part I've played, of course, since I moved to that report, after it was made, then I moved to the Court of Appeal. And so my contribution would be confined only to the Court of Appeal. And just to say that those devolved functions for administration have been quite useful, and we've been able to use those officers who have been sent to our various courts. And they have really helped in easing. We have the supply chain officers in our courts, and they've been quite useful to us. And I think I can say that we now have indeed taken away magistrates and judges from the corridors and from the loans.
Thank you, my lord. Is my lord aware of the implementation of the org review process ongoing?
Thank you, my lady. I would have said that that has really gone a long way, looking at even the proposals, the harmonization and the rationalization of the structures, the work that has happened. I believe that under the Honorable the CRJ, there's a team working to sensitize the staff. I can only say, like most of the things that happen in the judiciary, the judges are normally not quite involved. And so I hope that as they sensitize the staff and everybody else, that they'll remember to sensitize us.
My lord, we've had committees since your days. You're properly an insider. That's correct, my lord?
Yes, I am.
That is what you are. We've had all manner of committees around here. Do you know what has happened lately about those committees? And what is the involvement flowing from what we've just been discussing of judges and magistrates in that aspect?
Thank you, my lady. There have been too many committees. I've lost count. There was a time, perhaps there were like 2015 and
42?
42. Incredible. I really don't know what they were doing, and it concerned me that for every little activity there would be a committee. It concerned me, and it completely adversely affected the main work we do in the judiciary. A lot of time is taken in these committees, and I know that they have all now been collapsed. They have been reduced. I can't remember the number. I think there's 7. 6. Which, to me, my very honest view, may still be too many, because in my court alone, I think, save for myself, who is not in any of those committees, and maybe 2 other judges or 3, most of them are in those committees. And the way the committees meet sometimes in the course of the week can affect our core function.
And so, my lord, will do something about that. I think it's fair to say here, we have nearly almost removed everybody who is a core deliverer of access to justice from those committees, save for just 1 judge, 1 magistrate, max. We've removed all the others, and these reports are available, except, of course, for the statutory
committees.
Now, This institution has been talking transformation since 2011. When will we do transformation and stop talking transformation? And how long is enough?
Thank you, my lady. We started with the word reform, and then 2010, going forward, we moved to transformation. But my lady, transformation in the judiciary or reform in the judiciary started much earlier. The Ramtu report, the Mbithi report. There have been many reports. There were the Quach report, Nyango Tieno, my lord, Mr. Tony, the Kiara Karaoke report. There have been many reports. There has to be an end to more reports. And as I said earlier, reforms are progressive. We've reached a point where we have enough reports. It is time now to implement.
And so what, sorry my lord?
Go on, yes.
So what would my lord do to make us achieve a most effective implementation?
The two main blueprints currently that I think have subsumed most of the recommendations in the previous report is the starting point, our strategic plan. As I said, in order for one to move as a leader, you must get views. And so I have my own view, which is we must move and have results. When Chief Justice Mutunga took over, it is said our backlog stood at 1 million cases pending. As CJ Maraga retired, we are, I think, at 700,000. And the focus should be that, because what Mwananchi wants us to do is to give expeditious determination of cases. And that will be my approach. I know what Mwananchi wants. Go to any court, Kerugoya, Busia, meet any litigant in the court corridors. Ask them, what is one thing that disturbs them? I keep coming to this court. I've come to this court 5 years, 6 years. The focus should be instant delivery of service.
Thank you, my lord. This institution has been trying to operationalize the institution of tribunals, which are part of the judiciary. I think it's Article 169 or thereabouts. Might my lord know, one, what challenges we have met there, what success we have achieved, and what my lord would do. In fact, the import, let's take it this way. First, the importance of the tribunals, the challenges we have faced, my lord, any successes, any, and whether the discharge of function of the tribunal is a distortion of the core mandate of the judiciary as regards alternative dispute resolutions.
Thank you, my lady, again. Yes, tribunals are described in the Constitution as subordinate courts, and so they ought to be part of the judiciary. Tribunals are important. They are specialized. The rules of procedures are not as strict as those of court, and so they dispense justice faster. It is so believed. Tribunals are become fashionable. Again, I've lost the number. I don't know whether they're 60 or 70. It's become fashionable for any legislation to have a provision for a tribunal, which is a good thing, as your ladyship has noted, as part of alternative ways of resolving disputes. We've faced challenges with the tribunals because the transition has been long. I believe there must be some resistance. If I was given the power to appoint people to positions and this power is being taken away, I'll definitely, as a human being, to be very happy. So I believe there's some resistance. I'm aware that we've made strides. There was a committee, I think chaired by my Lord Mr. Justice Ntoinoti, that made recommendations to the Commission as to which tribunals can move. And I believe with the recent decision by Mr. Justice Mrima that we ought to finalize this as soon as possible. Looking at even the arguments before him, the Attorney General didn't seem to have serious resistance or problem with this process being moved. The main issue appears to be the legal framework, and I'm aware that there is a bill 2019 which ought to be fast-tracked. And so I think the first thing that I would do, if you honor me, is to fast-track this bill so that we can be able to have them in. Tribunals are important, and that's why Kenyans in the Constitution thought that they are part of dispute resolution mechanisms and systems. And so they help us with these 700,000 cases. There would be more if tribunals were not there. So they play a critical role, my lady.
Thank you, my lord. Save that they are not the alternative justice systems. They are mainstream judiciary. And so the alternative dispute resolution mechanisms are those other ones, the arbitrations, the mediations, the AJSS, and the question still remains whether the alternative dispute resolution mechanisms may distort our core mandate. May they?
No, I don't think they'll complement.
They'll complement. Let's go to something else, my lord. And it is this. The magistrates, you, my lord, will agree, carry the greatest load of enabling access to justice in the institution. Is that a correct statement?
True.
Where are their decisions reported?
Yes, the magistrates are the first port of call. They are the face of the judiciary. Perhaps 90 or 80% of Kenyans who come to court end up there. They make decisions. Unfortunately, the law establishing the Council for Law Reporting does not seem to recognize that. I was a member of the National Council for Law Reporting at its inception, and it's something we discussed, and it's something I think needs to be discussed further, because it is imagined that when magistrates make decisions, they are decisions that can be overturned immediately by the High Court, or confirmed by the High Court again, but overturned by the Court of Appeal, and therefore they do not have any binding effect. But something we were discussing in the council was whether they could have their own way of having their decisions reported. But again, for what I've just said, because those decisions can go up to the Court of Appeal, perhaps even to the Supreme Court in some instances. So why would we have different levels? What we do normally, even in the Court of Appeal, when you cite a High Court authority, we ask you, and I believe you do this also in the Supreme Court, we ask the person citing it whether that decision stands or whether it has been overruled or confirmed. Because sometimes people cite authorities that suit them, but authorities that may have been overruled. And so all I would say is that for that reason, that eventually the decision that will be binding are those decisions of the superior courts on the magistrates' courts, that it would be, I don't want to say a waste of resource, but it would be superfluous to have another law report.
My Lord, the NCAJ, which my Lord will be chair of, has not found it prudent to have decisions by the courts that discharge nearly 80% of the work we do. Last I checked was 70. Is that a gap? And so, what is my Lord Chief Justice? As Chief Administrator, I'm remaining there. Will shortly move to Chief Judge. What is my Lord going to do? Is it not important that the work that magistrates do should be reported? And if it is not reported in Kenya law, should it not be reported some other place, my Lord? Or is that what you're saying, we should not have another report?
Sorry, my lady talked of NCAJ. I got a bit confused, but I got the question. Is the Council for Law Reporting?
It is actually under NCAJ. That's right. The work of my Lord as chair there. All these other bodies feed into that body, isn't it? And so, my Lord, the direct question is that Kenya law, because of what reason, by the way, has decided that the work done by the magistracy should not, has so far not been reported. Okay? Is that a gap? Is that a good thing? And if it is a gap, then what would my Lord do to fill that gap? But if my Lord feels that it's okay the way the situation is, then you discuss with us.
I reiterate, there are many good decisions. I just shared with you some of my decisions when I was even a magistrate. And so there are many good decisions that come from those courts. They ought to find a place somewhere. But I think the issue is the law. The Act, I think, foresaw only superior court's decisions. So it's a matter, perhaps, I'm not quite sure what, I can't remember now. If it's a matter of the law, then the law has to be amended.
Yes, it's my Lord's role as chair, as chief administrator of the Judiciary, that my Lord would play towards getting this, I think, big gap being filled, whether by amendment of the law, whether by some other form. That's what we're looking for. Let's go to what I think is my last part, second last actually. My Lord, as Chief Justice, would be chair the Judicial Service Commission. My Lord would be Chair EACJ, and my Lord would be all over the place, so to say, a minimum of 5 places. I call them 6 because of the rules function, and so many others that are not under statute. Now, that is time consuming and would require very serious time management, planning how to utilize one's energy to still remain relevant in each of those many roles. Would my Lord please tell us what prepares my Lord for multitasking, and which role my Lord considers as the most important of the many hats my Lord would wear as my Lord Chief Justice?
Thank you, my lady. Yes, 5 very critical roles, very, very critical, head of the judiciary and all that. They are all equally important and must be given equal priority and chance. What prepares me to juggle this is the background that I've given you, that as registrar of the courts, I was able to wear more hats and was able to deliver without losing my head. As a registrar, you are an accounting officer doing a budget, defending the budget, accounting for expenditure. You are also what they call, I don't know whether it is still relevant, you are also the authorized officer dealing with HR matters. You are in supplies, as we called it then, a library, and even outside the country, you are a member of some community in a committee in the East African community. I went through all this, so my training, my experience and background prepares me to be able to wear these hats.
And to wear them effectively, my Lord.
Yes, yes, my lady.
I don't feel that I should leave this area before we discuss just 3, which are the most important priorities we have identified for moving us to the next level in our strategic plan on the common date of the Judiciary 2019-2023. Would my Lord kindly discuss very briefly those and tell us how my Lord will ensure that we get there?
Thank you.
On the common date.
In the strategic plan, I think the strategic plan identifies 8 key areas. The first one would be on access. Access in its very broad term, opening up courts, making work efficient, delivery on time. The second one is on issues of integrity, the strengthening of the Ombudsperson's office, that has been identified too. And of course, there's the issue of leadership, enhancing responsive leadership in the judiciary.
On access to justice.
Honorable CJ, I hope you are winding up because time is going.
All right.
Thank you.
On access to justice, which is core, and on organizational sustainability, which also is core, and on the corporate identity, which is also core, I would imagine that one of the very serious issues we would have to settle would be this problematic caseload, how to manage it, so that we remain relevant. My Lord, as you hear, we've run out of the time allocated to me, but let me ask one final question. Judicial discretion. What is it? When may it be misused? And is my Lord aware of instances of misuse of judicial discretion? And my Lord, I wish you the best.
Thank you, my lady. Judicial discretion is the inherent power given to a judge or a judicial officer in law, in the rules, to make a decision. I know that in many instances we have properly exercised our discretionary powers, but I'm aware something that concerns me most, the discretionary powers used in interim orders, ex parte orders. That concerns me quite a bit. We have seen people running to court last minute to get such far-reaching orders which are issued ex parte, and sometimes we don't even reflect on the ramifications of those orders. That is one area. I can't say it is being misused or abused, but given the effect, I think it's an area that ought to be looked at very, very carefully. Thank you, my lady.
Back to you, Chair.
Thank you very much, Acting CJ. Thank you, Judge. It is now the turn of Commissioner Judge Wasame to ask these questions.
Thank you, Professor. Judge, once again, welcome. Judge, you have talked about how you have transformed the Court of Appeal. Now you will be head of the institution of the judiciary, and in particular, you will be the president of the Supreme Court. Tell us one thing you see as a problem in the Supreme Court you will solve within your first 60 days, if given the opportunity, God willing.
Thank you. It's a tricky one. I'm not in the Supreme Court. I'm not able to identify a problem. But going by the current discussions, going by the general feelings, of course, there have been many criticism of the court, whether right or wrong. I personally think that we have had very good jurisprudential guidance from that court. Just read judgments of the superior courts below the Supreme Court, and you will notice that we make reference to their decisions. But there are criticisms. All courts are criticized, including our court. I think the Supreme Court, having done 10 years, there ought to be some audit, some introspection. The equivalent in the UK, which was born 1 year before ours, had their reflection period, where you introspect, look at whether these criticisms are grounded or are just hot air. And that's all I can say, that perhaps it's time for us as a court to have self-evaluation and even involve scholars, to help us really break down these criticisms. Thank you, my Lord.
My Lord, again, the timelines provided under the Constitution, under the Elections Act, in terms of resolution of election petitions, is designed to facilitate quick resolution of the dispute. From the magistracy, the High Court, the Court of Appeal, to the Supreme Court. Of course, I agree that there is timelines for magistracy, High Court, and the Court of Appeal, the 6 months. But I have not seen any constitutional requirement other than Rule 28 of the Supreme Court rules. I have also read the strategic plan of the court 2020-2024. Of course, it has a catalog of fundamental landmarks achievement which the court has done. But one thing that is missing is the timelines for resolution of election petitions. I have noted from my own research, sometimes they take 9 months, others take 8 months, others take 12 months. So how do you intend to resolve that problem and ensure compliance with Rule 28.1 that provides 90 days from the last day of the hearing?
Thank you, my Lord. Apart from the presidential one, the rest don't seem to have timelines, election petitions that end up there. But your question concerns rendering of a determination within 90 days. Long time we used to have judgmental notice. I'm saying long time because it's been discarded in most courts. If you give a date for judgment and 90 days pass, I think the rules require you to explain why the date, the ruling or judgment has not been delivered within that time. And so if you go beyond 90 days and there's no explanation, then that ruling or judgment becomes one on notice, which is something that ought to be discouraged if it is there. People come to court with grievances, things they cannot agree on, things that are dear to their hearts, and they want results either way. And so if you do not render a decision within those timelines, which were set deliberately for a purpose, then you have not rendered justice. A colleague in our court says it is like cooking. You can't be in the kitchen forever. People want to eat, bring food on the table. We bring judgments on the table. So I'm not answering that because I really don't know what is the situation in the Supreme Court. I'm just giving a general answer as to the 90 days.
Thank you very much, my Lord. And secondly, you have also talked about how, under your leadership, the issue of the backlog and ownership of decisions by the Court of Appeal has been very impressive. How do you intend to translate that record all across the judiciary?
Again, the concern has been in a collegiate court whether we need to write separate decisions. When you write separate decisions, you are thinking, your philosophy is espoused. It is something provided, I believe, in most, or if not, perhaps all of our rules. And there's a reason why that is so. And so I would encourage people to write separately, but we face challenges when it comes to numbers. If you are each, like in our court, if you are each to write each time we had a matter, the time taken, you'd have done 2 others. And so, although the rules say as a general rule that separate decisions will be rendered, the reality is that it's not possible with our numbers. But it's an important thing to follow up.
Again, judicial officers all across the board have been accused of having inbuilt administrative nightmares and insensitivity to the citizens of this country. One area of concern to me is how sometimes we treat the elderly, terminally ill people and succession disputes. What is your idea of how to resolve or how to target those specialized litigants before court?
I'm told of an example of an old case at the Milimani Court of a paraplegic lady who has to be carried by people on the stairs up to the court. I'm aware we don't have ramps in most of the courts. I'm aware we have no braille facilities for those who are impaired in their sight. And there are so many categories of people who seek our services but are not able to get them. And if ourselves as judicial officers, judges, are not able to treat them when they appear before us with the respect, then that worsens their situation. So there are reports on how to deal with these categories. Even the task force I chaired had elaborate report ways of dealing with that. The strategic plan that we have ways of dealing with this. Really just to implement, to make sure that everybody who comes to court is catered for. Those who cannot hear, we have interpreters. Those who cannot speak the language of the court, we have interpreters.
Again, another area where we have been accused of being insensitive is that judicial officers keep files after the delivery of the judgment quite some time, sometimes even inhibiting the right to appeal. What do you intend to do about that problem?
Very true. Perhaps not widespread. And the question is, once you deliver judgment, what is your interest with the file? That is a question of discipline. Because once you deliver judgment, time kicks in for many things. People want to apply for stay. People want to extract orders to execute. People want to appeal. So if you keep the file and there is evidence that you did that deliberately, it wasn't in the typing pool, that's a case for indiscipline.
Again, another problem is how to get fines and deposits refund from the judiciary. That's also another nightmare. How do you also intend to resolve that problem?
A nightmare indeed. When people come to court, you give a conditional stay, pay 2 million, and you get a stay, deposit in court. You come to court, you are fined, you are acquitted. Whatever deposit you place in court, that is your money. I'm aware in the past we used to have district treasuries. I'm not quite sure whether we still go there, but I'm also aware that almost up to 70 million shillings are tied in these district treasuries. And I'm aware too that there's a process to try and resolve that. Yes, but to answer your question directly, we must have a system, and I'm aware we are having JIFMIS that should be able to deal with issues of deposit instantaneously.
Another problem facing the judiciary also is the transfer policy for magistrates, judges, especially from the High Court. It is very effective in the Court of Appeal, as you know, but it is not followed for the High Court the magistrate caddies and the staff? How do you intend to resolve that problem?
Transfers can also be described as nightmares. They disrupt families, they disrupt court work. It affects even litigants. And so when the judiciary leadership thought of having a framework, it was a great idea that people can plan. And as you have correctly, my Lord, noted, in the Court of Appeal, that is known 2 years before you move to a next station. So your second year, the month of April, you start packing, and May you are in your new station. Nobody comes to say, I have a little child, I'm going to college. Nobody. It is something that has been accepted. The High Court and the other courts of equal status also have a policy. I know that policy has not been adhered to. I know magistrates and the judges who have been transferred within 6 months to so many stations, 2 or 3. There must be a way of institutionalizing this policy so that people know, people can plan. There's a financial aspect to it as well. If you move people, each time there's money paid as transfer allowance. The officers have to hire transport at the expense of the judiciary to move their household goods to the new stations. So there must be a firm policy that is known. Obviously, there are exigencies of duty. There may be a reason for a judge or a magistrate to be moved at once, but it cannot be very common.
Again, my Lord, you talked about having, during your short time as the President of the Court of Appeal, you have given an identity to the Court of Appeal in terms of delayed judgments, in terms of ownership of the decisions, in terms of getting dates within the reasonable time. How do you intend to give courts like the Commercial Division, which is sometimes unfairly accused of having lost its identity, the Labor Court, which is sometimes unfairly accused of being pro-employees court, the Land Court, which is also sometimes unfairly accused that it is nightmare to get a hearing date from that court. How do you want to give those 3 divisions or 3 courts an identity?
Yes, the accusations are there, I've heard them. But we must understand the background why we have these accusations. Really boils down to numbers, judges. So when you hear that your matter that you filed in 2020 will not be heard until 2025, then you know something is wrong. So to begin with, the identity that they must be given is expeditious disposal, which they can only achieve if they have the numbers. They can also get that identity by being active in case management of the cases that are before them, to be able to identify which cases have been there long, and to identify those cases that are urgent in nature. But the whole thing boils down to capacity. Thank you.
And lastly, another nightmare facing the judiciary or the administration of justice, my Lord, is the Marioteto case. The Supreme Court, respectively in my view, dealt with the circumstances, the degree, gravity, and the culpability and the exceptional nature of the death penalty in terms of section 203 as read with 204. And what the court said, from my reading, I could be wrong, is that the two accused persons, and the court, let me start by saying, this decision, the court was very specific and said it only applies to these two petitioners, Mariotetu and Mangi. Again, the court did not set aside the death penalty, which was imposed by the High Court and also upheld by the Court of Appeal. But they remitted back the matter to the High Court for resentencing. And what the court was saying, in my view, is that a formal equal penalty for an equally wicked crimes and criminals is not in keeping with the tenets of a fair trial. And the court said, anybody who thinks there is a problem of the death penalty need not to approach us, but go to the relevant court, and then they come to us. And they said, the AG to set up a framework to deal with the sentence and rehearing of cases relating to the mandatory nature of the death sentence. Of course, the point I'm raising, my lord, is that there has been a remarkable concerns that that judgment has been misused and abused and misunderstood and misinterpreted by all the courts, from the Court of Appeal to the Magistrate Court. And now it's free for all. How do you intend to resolve that nightmare as CJ Ouko?
Thank you, my lord. On a light note, I think Kenyans must be wondering this Multitasking man that is being discussed in this tent from the time we started. Perhaps the commission may want to introduce him at the end of your exercise. He's a great guy. He very resilient. He brought a change to our jurisprudence. Multitasking, a very resilient man. Having said that, perhaps we go back to the decision of the Court of Appeal just a month before the promulgation of the Constitution, the Ngotham Mutiso, where the court was faced again with the 204 crime, section 204. And the court was very specific. The court said this decision is limited to this case and to the mandatory nature of death sentence under section 204. And it went on to say that it perhaps may apply to the other capital offenses, and they named them: treason, robbery with violence, attempted robbery with violence. They said a day will come when that will be resolved. But for now, Ngotho's case ends with the determination that death penalty is not the only punishment that you can be given when you commit murder. Then, of course, came a 5-judge bench of the Court of Appeal a few years later in the case of Joseph Maura, and the same question arose, except I think Joseph Maura was robbery with violence, but the principle of the mandatory nature of the death sentence was still at the center of it. And the court said, we have no alternative. The law says you murder, you commit robbery with violence, it is death, nothing less. Then the Supreme Court came. The Supreme Court agreed with the first case, Ngotho, and said what it said. The two issues that I think have been raised, that after that decision, there's been confusion. I think the courts and the practitioners ran to town. The Supreme Court had said, hold, they had actually said what Ngotho said, that this case relates to the circumstances of this case. But the Supreme Court, in my view, said two things that perhaps has caused the confusion. The first is, I think, paragraph 48, which I think people have misread. Paragraph 48 of that decision, the court says that you cannot take away discretionary powers of a court in sentencing by an act of parliament, that is not the role of the legislature. Of course, they've gone on to explain again that it was really in relation to what they were saying. Personally, I don't think they were saying it generally. Then they asked the Honorable the Attorney General to come up with a framework, what they call structural interdicts. And I think perhaps people waited and became impatient. There was no direction, and we took the law in our own hands, hence the confusion. I can't blame the Supreme Court. Had we held our hands, had we waited for the framework, perhaps this confusion would not have been there. So what I'll do, if you allow me to be the Chief Justice, because the Supreme Court did not finish its work. It gave an interdict. Have a mention and hear what the Honorable the AG has to say with regard to the assignment that he was given, now nearly 3 years, and you make a decision from there. Thank you, my Lord.
Thank you, my Lord. I wish you well. Thank you, Professor.
Thank you, my Lord.
Thank you, Judge Wasame. Thank you, Your Honor. I think we have now questions from Commissioner Judge Majaja before we take a break. Commissioner.
Thank you, Chair. Good morning once again, my Lord.
Good morning, sir.
One of the tasks I've been given is to deal with your writings, not necessarily to interrogate the reasons, but just to satisfy the Commission that you meet the standard, and I must say that they are very impressive. We have 4 judgments. The first one is in a civil appeal, Kenya Hotel Limited and Oriental Commercial Bank. Another one in Elizabeth Wambui Githinji versus Kenya Urban Roads, and a ruling in Judicial Service Commission versus Honorable Lady Justice Kalpana Rawal. What I read from those decisions, first of all, they are your individual judgments. In 2 of them, you actually delivered the majority decision, and there were dissenting decisions. I think one of the issues I had raised with your colleague, and probably you followed that debate, and you mentioned it, is the level of accountability for individual judges in the Court of Appeal or in a collegiate court to the public, being able to write your own decision. And my view and assessment, and correct me if I'm wrong, over the period the Court of Appeal has not done very well. You've been writing joint judgments, and when I look at other courts of your status, Supreme Court of Appeal South Africa, there are 5 judges, but normally, even when they agree, it is one judge who writes and he's identified. Look at Tanzania, look at Ghana, that's what happened. So maybe you want to tell the public why this is a different position. And in fact, if you look at the old East Africa Court of Appeal, that was also the position. That's why we know Madan, that's why we know Diebold J said X, Y, Z. Why is that?
Yeah, thank you, my Lord. Yes, it is very important to not have known Nyirangi was a great judge, but his decision, one decision that has stood the test of time, the Lillian S, has his name on it. And so I can't overemphasize the need for a collegiate court to have separate opinions. It is in our court, there are those who think we should be doing separate judgments. But there are those who think that the reality is that the numbers cannot allow us to do that. Because if you hear one matter and each one of you has to write a reasoned judgment, the time you take to do that in one case, you'd have done two others. So that's one reason, not a very persuasive reason, but it's based on the current number of judges. And we had actually resolved that when we get the 11 judges, that is going to be the way, because it is provided for in our rules as a general rule that to begin with we must write single judgments. And so I want to admit to the public that that's one area that we haven't done very well on account of our capacity.
Because, and I agree with you, it's not a very good reason, because it is one judge who writes. Once you agree, you conference, you say, Judge so and so right, and the rest just concur. So it doesn't add, unless the case is of such magnitude that you feel that you need to write single judgments. It's normally you agree as a panel, and then one judge writes and the rest concur, and that's what I've seen in the other jurisdiction. But let me go to the next question, and this is a quote from a young jurist called Walter Kobe on the Court of Appeal. It's a quote, it's out there, and it says as follows in the platform. If there's a group of people whose ideology is contrary to the spirit, values, and principles of the 2010 Constitution, it is the judges of the Court of Appeal. In fact, if there's a group of people who are irredeemably mired in a legal culture of liberal legalism, that is formalism, positivism, rule-bound technical approach to adjudication associated with the pre-2010 dispensation, and are oblivious to the demands of change in legal culture demanded by the 2010 Constitution, it is the judges of the Court of Appeal. So this is criticism. So, as the president of this court, is this statement true? And probably you would give me examples or give the public examples why you think this statement is not true or correct, as you may.
I'm actually surprised. We thought we were doing our best. We thought we were progressive. And so I do not know where Mr. Kobe did his research, if he's able to identify decisions that he thinks are not progressive, because that's what we encourage. Even among ourselves, we sometimes reflect on our decisions where we have gone two different ways. And we have invited people to come and talk to us from the academia, from the legal practice in the court, in order to be able to have this robust jurisprudence that we talk about in the judiciary. So really...
So can you give us an example of what you consider progressive jurisprudence from the Court of Appeal?
There are many, my lord. There are very many.
Because you have to answer this question, so give us two examples.
We have made decisions in election petitions that have gone to the Supreme Court and upheld, and so many other decisions. This Muruatetu and all these things we are discussing all pass through the Court of Appeal. So I think it is unfair criticism without detail. And so it's to answer...
So for example, he says Mitubel, one of the decisions he discusses, the decision of Mitubel.
Right.
Of course, Mitubel has now been overturned by
Supreme Court.
The Supreme Court. He also mentions this decision which you quoted, this one of the decisions in your this position in Elizabeth Wambui, the one you gave the majority decision. Another one, for example.
Me too, Bell. Yeah, so it's good when somebody criticizes and gives you an example, then you are able to respond. Of course, the Me Too Bell, the main reason was the way the Court of Appeal did not reflect on the issue of structural interdict. I think that may be a valid criticism. Okay. I want to admit. I don't know what the problem with Wambui case was.
This is, in fact,
the Runda?
Yes, the Runda case,
right.
About illegally acquired land.
Yes.
And in that respect, I think there have been several decisions that are conflicting on how the courts should deal with the illegally acquired land from the Court of Appeal, and that has actually caused a lot of concern in the lower courts. The Court of Appeal has given conflicting views on that particular issue.
Yes, I can talk about the Runda one. It is more or less Me Too Bell, if you asked me, except maybe for the area where these people are. They are in Runda. Me Too Bell was Mitumba village. But save for that, if I sat in Me Too Bell, I would have done the same as I did in the Runda case, because these are people who settled on that land from the 70s. The road on which they say to have encroached was built, and cars drive through it. The surveyor, government surveyor, confirmed that that stretch of the road, the width was 60 and not 80 meters. And what was going to happen to nearly 300 families was to have their homes demolished. Some homes were 35 million. That's not really a big consideration, but the fact that they had titles issued by the government, the fact that the survey was done by government surveyors. So I would say that if I sat in Me Too Bell, I would have come to the same conclusion like the Runda decision.
In Me Too Bell, the court seemed to cast doubt on prescriptive rights. If you read the decision, they seemed to suggest that prescriptive rights are not permitted. You are aware of that?
Yes.
Yes. But then in a very decisive case in Malindi, when you were sitting at Malindi, now in fact this is a case where the 3 judges gave very considered opinion on the constitutionality of adverse possession. You recall Tana Lewa?
Yes.
Very detailed, and you rebuffed any suggestion that prescriptive rights over land are unconstitutional.
Yes.
So, do you think it's right for the Supreme Court to cast doubt on prescriptive rights, particularly when that was not an issue before them?
That's a tricky one also, because Article 163, I'm bound by their decision, and I can't say that they were wrong. I can only say that we decided Mtana Lewa on the matter that was before us, the question being, is adverse possession unconstitutional? And we said it is not, because there are procedures to be followed, there are conditions to be satisfied before you get title under adverse possession. The possession is not arbitrary. That's what we decided in
my position is really, and the question I'm asking this is because you'll be sitting in that court, and just as we have been discussing, the obligation of the court is to be careful about what they talk about, isn't it? very circumspect. And by the way, probably that is why the Court of Appeal is always condemned sometimes, because you actually sometimes take a narrow view of the issues you have. So in Mitubel, the issue was squatters on public land. But the court went ahead and suggested, and that's why I'm asking you whether that's a correct assertion by an apex court. It suggested. So you sitting as an appellate court, would you approach that issue in that way?
One thing I was taught when I joined the bench as a judge, having been in administration for so long, those old Court of Appeal judges told me that decide a matter on the basis of what is before you. You may have great ideas you want to put in a matter, wait until the occasion presents itself. And so you're right that we are very, very circumspect when it comes to the matters that we deal with. If you think that you do not want to be bound by a statement that was made, what colloquially would be called out of context or in per curiam, then you go for the main decision that the court made, and you do not have to follow what was not before the court.
And now this brings me back to Muruatetu, because again, it goes to the same way decisions are made. So you have told us, and again, correct me if I'm wrong, the issue in Muruatetu concerned Muruatetu, this man whom we talk about but we don't know. He has been sentenced to death. All the court was saying is that the mandatory death sentence, just as the court held in Mutiso's case, the same thing, but that was pre 2010. This is after 2010, reaching the same conclusion that death sentence is not mandatory, or the mandatory nature of the death sentence is unconstitutional. What did your court, and again I'm saying this because it's your court, say about Muruatetu in respect of sexual offenses?
Yes, again, we just borrowed paragraph 48, that we have been given guidance by the Supreme Court in the sentence where they said discretionary powers cannot be taken away by a statute. And so we ran to town. We are now applying it in sexual offenses, and I believe there are other offenses where perhaps other courts are applying it, where we have minimum sentences. As I say, it is not neat because of the confusion it has brought to the judicial system.
So the court is basically, what the court in Muruatetu was saying is the legislature cannot take away judicial discretion, cannot take away the judicial function and arrogate it to itself. That was the principle. So what is wrong with a court anywhere sitting saying, the court, forget about the offense, what is wrong with a court sitting anywhere saying that this is what the Supreme Court has said? There is nothing wrong. Is there anything wrong? Because that is basically the decision, that is the foundation of the decision.
Yes, and I said we had a similar decision in 2019. No, it was July 2020, the Mtisongotho. But people didn't run to town. We did not interpret it to mean, and they said the same thing about discretionary power. So I think as a general rule, really, that's the law, that the powers of the court cannot be taken away when it comes to issues of sentencing. but it's the way it is being done now that appellants from the Court of Appeal go back to the magistrates' courts, irrespective of the offenses, and they're having those sentences reviewed.
So, who can you blame? No, that's bad. So, actually, the fact is, Supreme Court met. So, who are you blaming for that particular mess? Who are you blaming? Because people are entitled to go to court anywhere.
I don't want to blame anybody. I want us to get a solution to the problem.
Okay. Now, there is another case, again, which this case of Kalpana Rawal and others, JSC versus Kalpana Rawal. And again, it's one of the decisions you gave, and this was a 5-judge bench. All the judges gave separate decisions, I believe because of the magnitude and importance of the decision regarding the right of appeal. The Supreme Court has now come up with another right of appeal. I take this from my colleague, restlessness of jurisdiction. It is called restlessness. And I call it residual jurisdiction, coming from Newton and the cases. So what is this residual jurisdiction?
In relation to Newton?
In relation, actually, let me take, in this case, you are very clear, and this is what I always understood, that a right of appeal can only be conferred by the Constitution or the law.
Yes.
That's what the court was saying here. And in light of Section 163, right of appeal to Supreme Court on constitutional issues, it meant that in fact there was a right of appeal to the Court of Appeal. Am I right?
You're right.
That was the law. But there is another residual jurisdiction that has come up that says, and this is, says, if there is an error so grave, the court must be able to intervene. That is the Newton jurisprudence. Are we on the same line?
Yes.
Yes. So what is the problem with that kind of decision? What do you see going ahead where you sit? We've already talked about the problems in Muruatetu, in the other cases. Now let us look at this residual jurisdiction problem.
Lord, I think I said at the beginning that there are many issues being raised about decisions of the Supreme Court. And I said also that the Supreme Court has been giving us, in many cases, the ones that they're being criticized are isolated. By and large, we've been getting guidance from the Supreme Court. Hamana's Koinange investment defines the jurisdiction of the Supreme Court. And now, from what people are saying, there seems to be some mix-up, that the door seems to be opening. Yet in the Koinange investment, the Supreme Court said that there's a sieving mechanism, just the way you sieve tea. Tea leaves remain in the sieve, and only pure tea goes into the cup. That this mechanism ought to be strictly followed. But again, there's been talk that the door is opening wide and wide. And that brings me to what I said earlier, a time for us as a court to take all these things with our stride, sit together as judges, get all these areas where we are being accused, wrongly or rightly, that we have overreached. Let us reflect. let us get scholars to look at these areas that you are identifying and tell us this is the road, you have left the track. It is only through that that courts grow. And for me, it is all very well. If you criticize the court where I work, just show me the instances and we will look at it. It makes us wake up that there are people there who are watching us. The Supreme Court is so important to this nation that we must, as judges in that court, take these criticisms seriously, because institutions are run down when they bury their heads in the sand. We need to take criticisms positively and address them.
Okay. There is a case, one of the major cases you'll be dealing with are election petitions. You are aware of the decision in Martha Karua. You know the history of the Martha Karua case from the High Court, Court of Appeal, Supreme Court, High Court again. You know the history. You also know that it went to the East Africa Court of Justice. And the East Africa Court of Justice said something. It awarded Honorable Martha Karua damages for infraction of the Constitution. One of the commentators, again, I like reading criticism or comments, is called Caxton Higata. He calls this a legal brawl between the East Africa Court and the Supreme Court. As a Chief Justice and President of that court, is this something that would concern you, that people have to go outside the country for relief against what the Supreme Court itself has done, and how would you propose to deal with that kind of situation?
The timelines of election disputes. I sat in the initial one, in the Martha Karua one. We had hardly 4 days to the end of 6 months, I think so. In fact, I sat with my brother, Commissioner Warsame, and Judge Musinga, and we debated, is it worth taking back when they have 4 days? Where is time to be able to call evidence? But we said that is for that court to decide. We do our bit and send it back. And so it has rolled across the borders of this country and back. So again, without casting in aspersions, again, really just to review all these things. If it's the law, we are able to recommend what laws need to be amended or made. But the beginning is to reflect.
So what is your reflection on this particular case?
Reflection will have to be collective.
No. Now you're the Chief Justice, you're concerned because it would undermine the position of the Supreme Court if every litigant kept, when they leave your court, they go to East Africa Court and they are awarded damages. You can imagine what that does to the credibility of your court. So there must be something you can think about and you tell us that when I'm Chief Justice, this is what I would do.
Obviously, the credibility of the court suffers when people have to leave Kenya to go and seek redress outside Kenya. I really do not want to say more than I've said regarding the Supreme Court and what I will do when I get there, if you give me the chance, will to ensure that this does not happen, because we will have collectively to agree on how to deal with this situation.
Okay. Now, there is a doctrine called the political question doctrine in terms of constitutional adjudication. Can you just briefly explain to us what it means and where it finds its place in the Constitution, if it does, and where it finds its place, the political question doctrine?
Sorry to ask, is it something to do with justiciability?
Yes, sometimes referred to as justiciability or the political question. The court saying this is a political question, we will not deal with it.
Right.
So does it find its place in the Constitution, or what is the basis for the court saying that this is a political question?
I can't right away think of the provision in the Constitution, but there are disputes that are better resolved through political mechanisms. I know long time there would be issues of nominations by political parties, violations of rules and constitutions of political parties that the courts would be very reluctant to address. So I can't recall exactly what provision it is at the moment.
So is it an issue of, again, on the same point, is it an issue of jurisdiction or is it an issue of avoidance?
I think it is avoidance, because avoidance is to avoid flogging the Constitution too much. To avoid is to return certain matters to where they belong. And so I think this is one of those instances where avoidance can be used.
Okay. My last question, which we've asked all candidates, the court which you preside is the one, I believe, that has suffered most because of the 11 judges. In fact, one of your key, what I would say, limiting factors to your success, you have been successful, and for example, you have 67%, satisfaction amongst the public. But what is holding you back is those 11 judges, isn't it?
Yes.
Chief Justice Ouko, what is your solution to that issue?
Very true. My court has actually felt the brunt of this. When I joined the court, we were 20. No, sorry. When I joined the court, we were 27. Shy, the 3 judges shy to the complement under the Constitution. 27. And work was smooth. We didn't have to sit the way we are sitting now. And with time, this number has been dwindling. Judges have retired, a judge has died, and so we are 15. 15, if you take away myself, if you take away my Lord, Commissioner Warsame, if you take away the Director, Mr. Justice Ntoinoti at JTI, you have 12. That's a court that we sit 3. So 12 would translate to 4 judges. 4 judges dealing with appeals from nearly 200 judges from the courts below. And so we felt the weight because of this. And so when I talk about what we've gone through, it is really from my heart. There ought to be a way out. And for me, if you graciously give me the opportunity, I'll come back to you. I'll come back to the Commission. This is where it all started. To retrace our steps to find out where the rain started beating us, to find out, as it is now, I can't tell exactly where the stalemate is, but I know there are cases. I don't know the nature of those cases, apart from what we read in the papers. So I'll come back to the commission. And depending on what I get from the commission, and depending on what the commission thinks, of course, I personally, I'll have my own view that the solution lies with the head of state, and that's where we will take our grievance. I believe that as head of a branch of the government, as head of the judiciary, a Chief Justice has some structured channel of communication with the head of state. And if there is none, it will be really for me to establish that structure, channel of communication, which will involve all the three branches of government, because that's how governments work. A government has three legs like an African traditional stool. So those legs are the same. And if one is short, then you can't comfortably sit on that stool. So the eventual port of call will be at State House.
That is all, Chair. Thank you, and thank you, my Lord.
Thank you.
Thank you very much, Honorable Judge Majaja. Thank you, Your Honor. We'll now take a short break, 10 minutes, and we'll be back at 11:30. Thank you.
Thank you, Chair.